Now, the legal representative of President Cyril Ramaphosa, Advocate Wim Trengrove, has told the Constitutional Court that the public protector misread and misquoted the Executive Ethics Code when compiling her report over his AC presidential campaign funding. Advocate Trengrove says Advocate Mkhwebane made errors so obvious and so patent that no lawyer in good faith could have made in her finding that Ramaphosa had misled Parliament on the funding for his AC presidential campaign for 2017. The ConCourt was today hearing an application by Advocate Mkhwebane for it to review a High Court ruling that set aside her report and ordered her to pay a punitive cost order. So specialist legal journalist Karyn Maughan joins us now to look at the day's events. So, Karyn, let's first start with the errors Advocate Trengrove is referring to. And is it simply not a matter of difference of legal interpretation?
Well, I think the most important point here is really this issue of, do you deliberately lie to Parliament? Is that the violation of the Executive Ethics Code? Or is it a matter of inadvertently misleading Parliament? And that was the real issue that was at the heart of this matter, was that the public protector had essentially said that even though there was manifest evidence that President Ramaphosa had mistakenly told Parliament that this 250,000 rand, 500,000 rand payment, the account identified had been made done.
All right, let's just give it a moment so that the connection improves somewhat. I want to talk about this, the concept of deliberately. Okay, so Karyn, we weren't hearing you, but let's talk a little bit more about that concept of deliberately and inadvertently. So the meaning, according to the lexicon, seems pretty clear, but in the Executive Ethics Code, what is it that would have led to this conflation?
Well, it's actually unclear, to be honest with you, because there's a very deliberate line that, drawn between someone deliberately lying to Parliament and then someone, as in Ramaphosa's case, being seen to make a mistake based on the information that was provided to him at the time by the DA leader, Mmusi Maimane, mistakenly saying, look, this money went to my son, when Maimane said to him, this was an account that, this money was paid by Bosasa into your son's account. And then subsequently saying, actually, I've identified this account as belonging to the CR17 campaign, and this was a mistake that I made, and then writing to Parliament to correct that. There was a lot of confusion. I remember at the time when the report actually came out, asking the public protector about this issue. And her at the press conference being, there was a lot of confusion over her saying that, in fact, Ramaphosa had a duty before he answered these questions to make sure he was familiar with the facts of the matter and shouldn't have just said what he said, and that in and of itself amounted to deliberately misleading Parliament. So it was a massive problem in terms of the report. The High Court found that, there had been this misquoting of this particular act. And Trengrove's position is simply that, you can't make these kind of mistakes if you're in the public protector's position.
I want to talk about what Advocate Wim Trengrove was speaking about, whether or not there was a prima facie case against Ramaphosa and the evidence that he accused Advocate Mkhwebane of not having. In her report, does she point to the existence thereof? And I know there was also the issue of jurisdiction, which was raised by her legal team, saying that, in fact, she was well within her rights to make the kind of findings that she did, as President Ramaphosa was deputy president at the time, and this was a matter of issues of state business.
Well, essentially, the public protector is mandated to investigate possible state abuses, misspending of government money, etc. So essentially, the Ramaphosa position has been, well, this was my private political party funding, campaign funding. There's no way that it can be argued that, state money was involved in it. The public protector's position is, well, there is a potential for state capture here. There's a potential of financial irregularities and corruption, because if, the president is getting certain amounts of funding from people, you would expect that there may be a sort of sense of quid pro quo, that someone may feel that because they gave the president this money to further his political ambitions, that he became president of the ANC as a consequence potentially of this money, that he may feel obliged. And therefore, this is why it is important that this matter is investigated. And I think that beyond the parameters of Ramaphosa and Mkhwebane and whether he lied or he didn't lie, I think that may be somewhat of a sideshow. I think the real issue here, which was saliently raised by Mkhwebane and in some of the respects by the other parties, is this issue of, if the law does not require people who are involved in these leadership battles within parties to disclose who is funding them, then potentially there is a problem with the Executive Ethics Code. And as Stephen Budlender for Mkhwebane was arguing earlier this afternoon, it cannot be that the president would be required to declare 2 bottles of wine that he was given by someone, but not be asked to declare the funding or the 5 million rand in funding that had supported him in gaining leadership of the ANC.
Okay. So advocates Kakani further arguing that the Constitutional Court should grant direct leave for appeal, as the matter, as I mentioned, has to deal with the scope of the president and the public protector's constitutional functions and accountability. What would be the effect of this, granting a direct leave for appeal?
Well, essentially, in order to even get through the doors of the Constitutional Court, the public protector needs to show that she has made a case that it is in the interest of justice for the South Africa's highest court to make a final determination on the matters that are at play here. So it's about the interpretation of the Executive Ethics Code. It's about her jurisdiction to investigate matters of, of campaign financing when individual leaders are involved. It's really about these issues of whether she overstepped the boundaries by instructing, the Speaker of the National Assembly and the NDPP, Shamila Batoy, to, on one instance, force the president to disclose his funders in Parliament, and in the others investigate what Mkhwebane identified as prima facie evidence of money laundering. So, there are pretty pivotal issues at play here, and I do strongly believe that the Constitutional Court will make a determination that, there are grounds for it to have had this hearing. And I think the fact that they allowed the public protector to come into the court, to not go straight to the SCA, and to actually make the argument would suggest that they already feel that there is a basis for them to hear the arguments in this particular matter.
So, final question. We know that retired Justice Bess Nkabinde has been appointed to head up this panel that will, investigate whether or not there is a prima facie case to justify a parliamentary inquiry into Advocate Mkhwebane's fitness to hold office. Now, I'm curious, how much will this hearing at the Constitutional Court strengthen or weaken this?
Well, in the original DA motion for her potential removal or an impeachment process to be embarked upon against her, it was really the Constitutional Court judgment in the Reserve Bank matter, in which she was ordered to personally pay costs, and the Estina case, as well as certain allegations that were made by her staff members that formed the basis of that particular proceeding. So at this stage, this particular matter is not at play. But, we don't, because this is such an unprecedented process, we haven't seen anything like this before. It's unclear whether or not these subsequent issues or judgments will be brought into that process. Remember, of course, that the public protector is challenging the constitutionality of the rules that will govern this inquiry, and that case will proceed next year. She is currently in the process of trying to appeal a ruling that dismissed her bid to interdict that inquiry process pending her challenge to its rule.
All right, thank you so much, Karyn. Specialist legal journalist Karyn Maughan.